Hello students, I hope you are doing well. Today we are going to discuss another topic in the subject of law of contract. The title of our lecture today is Standard Form Contracts, Meaning, Objective and Nature. Let's delve into the topic. In this day and age, contracts are the cornerstones of commercial transactions. From purchasing a cellular phone to purchasing an insurance policy or subscribing to an internet platform, contractual agreements are part and parcel of everyday transactions. But unlike classical contracts negotiated between the parties, most commercial contracts in the modern era are not negotiated. Instead, they are pre-printed templates, homogeneous in character and non-negotiable, commonly known as standard form contracts. These contracts are commonly characterized as contract of adhesion, in which a party is presented with a bundle of terms prepared by the other in a take it or leave it format with little or no room for negotiations. Though pervasive, the character, enforceability and fairness of such contracts are issue of intense legal concern. The origin of standard form contracts has its root in the growth of mass markets and industrial economies. As the value and volume of transactions increased and operational efficiency gained greater value, firms began to employ standardized contract forms in an attempt to lower the transactional cost and accelerate the provision of services. This became more prevalent in sectors like banking, insurance, transport, real estate and e-commerce, where negotiation of every contract on an individual basis would be impractical and economically wasteful. Standardization of terms introduces consistency and knowability in commercial transactions, which is preferable for firms conducting a large number of transactions on a daily basis. While the fundamental cause of standard form contracts is basically efficiency in business, standard form contracts present a number of legal and ethical concerns. One of the most significant concerns is the asymmetrical bargaining power between the two parties. The draughting party, normally a business or a service provider, will be in a very powerful position over the weaker party, normally a consumer or a small business, who will have no real capacity to negotiate or refuse the contract. This calls into question the voluntary nature of consent, one of the foundations of contract law. If a person signs or assents to terms without being aware or agreeing thereto, the nature of free and informed consent is called into question. The second concern is the possible insertion of unfair or harmful stipulations like waiver of liability, compulsory arbitration or unilateral termination rights concealed in fine prints. These stipulations, while legally inserted, can more often than not be disregarded by the agreeing party and may cause significant legal disadvantages. Aware of this, courts in various jurisdictions have developed safeguard doctrines like the doctrine of unconscionability and the rule of contra profundum to protect parties against oppressive terms. In India, standard form contracts are governed primarily under the Indian Contract Act 1872 and are subject to judicial interpretation in the spirit of justice and equity. The Consumer Protection Act of 2019 too has a significant role to play in protecting consumers against unfair trade practices arising out of standard contracts. This lecture attempts to explore the definition, function and nature of standard form contracts both legally and practically. It attempts to outline the justification for their application, legal principles that govern their enforcement and the reaction of the courts towards balancing commercial convenience and contract fairness. From an appreciation of the theoretical basis and true impact of standard form contracts, we will be in a better position to appreciate both their usefulness and the protection requirement in their application. Now let's talk about the meaning of standard form contracts. A standard form contract is a pre-printed contract in which the terms and conditions are fixed by one party, typically a service provider or a business, and the other party, that is the consumer or the user, has little or no chance to negotiate. Also known as boilerplate contracts or contracts of adhesion, these contracts are offered on a take it or leave it basis, and the adhering party either takes the contract as a whole or refuses the transaction as a whole. Such contracts are used across the board in mass transaction industries such as insurance, banking, transport, telecom, e-commerce and employment. They are used so widely because they are cost effective. Individual contracts for every customer are not economically feasible or preferable. Instead, a boilerplate document facilitates easy transactions and administrative convenience. Standard form contracts often have lengthy terms such as terms of liabilities, terms of dispute resolution, termination and so on. But they often tend to be ambiguous and include complex legal language, making it hard for the common reader to locate essential information. The weaker party is thus likely to accept terms that are unfair or one-sided without knowledge or due to necessity. The Indian law does recognize standard form contracts as being enforceable under the Indian Contract Act of 1872 if they meet generic principles such as free consent, legal object and consideration. The courts have, however, developed protection devices such as the doctrine of responsible notice, unconscionability and contra profantem to protect parties from possible exploitation of such contracts. In fact, while standard form contracts play a pivotal role in modern commercial and consumer contracts by rendering speed and uniformity feasible, their character must also be subject to judicial scrutiny so that they are not taken up as instruments of unfairness. Now let's talk about the objectives of the standard form contracts. Standard form contracts are extremely powerful instrument in modern commercial and consumer contracts. They are used extensively in sectors such as insurance, banking, transport, e-commerce and telecommunications due to the functional and economic grounds on which they have been developed. Now these grounds are: first, efficiency in contractual transactions. One of the most important roles played by standard form contracts is that of enhancing efficiency in the execution of agreements. For companies dealing in areas that entail striking hundreds or thousands of bargains a day, it would be impractical and costly to draft contracts for every customer. Standard form contracts facilitate companies to streamline this by providing pre-drafted terms that can be uniformly used against similar bargains, with the benefit of conserving time and administrative costs. The second is cost reduction. Standard form contracts reduce the repeated costs of negotiation, drafting and reviewing contracts. For companies, it implies a significant saving in legal costs. Rather than needing the services of legal experts for each and every agreement, companies can use pre-tested models that have previously been found legally adequate. The third is uniformity and predictability. Through the application of standard terms and conditions, standard form contracts bring consistency to contractual relationships. This consistency makes all parties equal under the same obligation and benefits, lessening ambiguity and misunderstandings. Precedent outcomes also assist in the quick settlement of disputes, since the courts and parties already know the standard terms. The fourth is risk management. Standard form contracts are typically skillfully drafted to limit liability and allocate risk in a way that protects the party doing the drafting, oftentimes the company. Limitation of liability, force majeure, indemnity and dispute resolution provisions are drafted with anticipation in an effort to preclude potential legal risks. The fifth is mass commercial transactions. With the advent of e-commerce, online platforms and subscriptions, so too has there been a need to distribute goods and services to masses of individuals. Standard form contracts are developed to enable mass distribution and transactions by enabling customers to accept typical terms with little resistance, typically in one click or one signature. The sixth is clarity of terms. Although at times criticized as overly complicated, one of the functions for which standard form contracts are constructed is to provide an open and complete set of terms which can be utilized by a broad spectrum of users. Once explained or disclosed enough, they give parties an open legal framework with which to govern their relationship. Now let's talk about the nature of standard form contracts. Standard form contracts or addition contracts or boilerplate contracts are a special category of legal contracts that are primarily marked by their pre-formulated non-negotiable nature. Under such a contract, the terms and conditions are written by one party and the other party is merely requested to accept the same, usually without any level of flexibility or modification. This one-way practice of contract writing defines the most significant feature of their nature. Now let's talk about the different aspects. First, pre-written and non-negotiable. The key characteristic of standard form contracts is that they are pre-drafted by one party and presented to the other on a take it or leave it basis. There is no room for bargaining and the confirming party has to agree to all the terms or abandon the transaction. This is an important characteristic in those industries where mass contracting is needed. As we have discussed, these industries are insurance, banking, telecommunication, e-commerce, software licensing, etc. The second is one-sided bargaining power. The second fundamental feature of their nature is the unevenness in bargaining power. The drafting party would otherwise be in a superior economic and legal status and use the same to bargain the terms in its favor. The weaker party thus has no voice or has little voice, and the contract is thus naturally unequal. In most cases, the consumer does not even read the contract through, either because it is lengthy or because it is complicated. The third is efficiency oriented. Despite the lack of negotiation, standard form contracts are not problematic. Their efficiency and speed in enabling mass transactions cannot be overstated. Businesses rely on such contracts to handle thousands or even millions of clients in the same manner. Standardization reduces costs, make compliance simple, and ensure operational uniformity across transactions. The fourth is legal validity and enforceability. According to the Indian Contract Act 1872, a form contract shall be enforceable in law if it complies with the essentials of the contract, that is, free consent, legal object, legal consideration, and capacity of parties. The court have, however, become more cautious of the exploitative nature of such contracts, where there are unconscionable, fraudulent, or contrary to public policy terms, they can be held to be void or can be set aside or they can be interpreted narrowly. The fifth is use of advanced vocabulary. Standard form contracts contain fine prints, exclusions and limitation of liability clauses that an average person might not notice. These clauses are sometimes buried in thick legal jargons which is difficult to understand. For such clauses to be enforceable, the courts require reasonable notice to the weaker party, especially if the clause is extremely burdensome or out of the ordinary. The sixth is judicial safeguards. Referring to the internal asymmetry of such contracts, Indian courts have developed doctrine like contra profundum, that is, interpretation of ambiguous terms against the party who prepared them, fundamental breach and unconscionability in order to counter the harshness of standard form contracts. These judicial mechanisms are necessary in bringing about a balance to some extent between the contracting parties. Now let us talk about the legal framework governing standard form contracts in India. In India, standard form contracts are governed by the Indian Contract Act of 1872, supported by jurisprudential principles and consumer protection legislation. The Act itself does not specifically define and govern standard form contracts, but the principles of the Act as such permeate all the contracts, including those unilaterally written and presented on a take it or leave it basis. As per section 10 of the Indian Contract Act, a contract would be valid only if it is made by the free consent of the parties to the contract for legal consideration and with a legal object. Standard form contracts, however, present problems regarding the free consent of the weaker party because they are offered without leaving any room for negotiation. The adhering party is generally compelled to agree to terms which are predetermined, complex and even cumbersome simply to procure a service or product such as a mobile phone connection, insurance policy or online facility. Indian courts have nevertheless generally considered the view that if a party enters into a contract voluntarily, albeit standards in nature, they are bound by the terms thereof unless there is some ground for avoiding those terms. Section 23 of the Act applies when a term in a standard form contract is against public policy or so unreasonable that the contract is void. The courts have used this provision to strike down terms that are grossly one-sided or unjust, especially those which cap liability or deny legal remedies. In addition, the doctrine of reasonable notice, founded on English common law but incorporated in Indian law, stipulates that any burdensome or unexpected term in a standard form contract must be reasonably brought to the notice of the party subsequent to the time of contract. Its absence can make such terms unenforceable. Indian courts have also developed judicial maxims which protect the interests of the weaker party. The doctrine of unconscionability allows the courts to strike out harsh and unfair terms. The rule of contra profundum, a settled rule of contract interpretation, is used to interpret ambiguous terms against the interest of the party who has drafted the contract, usually the strong party. Another doctrine, the doctrine of fundamental breach, does not permit a party to exploit an exclusion clause if the party has committed a breach which defeats the fundamental purpose of the contract. Now, the Consumer Protection Act of 2019 also strengthens the statutory provision of individuals concluding standard form of contract as consumers. The Act declares unfair trade practices and unfair contracts and empowers consumer forums to cancel or modify such terms. Notably, the Act provides for protection of consumers from terms that cause significant prejudice. Example, terms to end the contract without consent, impose fines, or modify terms without consent. Now let's talk about the protective measures and reforms. Standard form contracts, while efficient and convenient, tip the balance of powers so heavily in the direction of the party that generates them, usually a corporation or a service provider, that the other party has accept the terms offered. Such a bias in balance necessitates the establishment of protection provisions and policy reforms to make the contracts transparent, equitable, and open to legal scrutiny. Both legislatures and courts have acknowledged such imbalances and acted to limit potential exploitation and consumer protection. The best protection device is judicial oversight. Indian courts have been actively applying the doctrine of unconscionability to strike down or limit the enforcement of unconscionable contract clauses. The doctrine forbids the enforcement of clauses that are so one-sided or oppressive, especially where the contracting parties did not have actual bargaining power. Moreover, the rule of contra profundum is applicable to consumer protection because it mandates any uncertainty in contractual clauses to be interpreted against the drafting party. This dissuades the use of imprecise or deceptive contractual clauses and demands more definiteness and responsibility on the part of the dominant party. Courts have also insisted on the doctrine of notice, particularly for exclusion or limitation clauses. The issuer of the standard contract is required to provide notice to the other party of unusual or onerous terms. The doctrine aims to ensure that even in contracts that are not negotiated, the weaker party is at least provided with notice of what they are contracting. Where the contract fails to meet these standards, courts will refuse to enforce the disputed terms of the contract. At the legislative level, Consumer Protection Acts constitutes a legislative check. The Consumer Protection Act 2019 of India is a prominent one in this context. It gives consumer the right to oppose unfair trade practices and seek redress of contracts with deceptive or unconscionable terms. The law also included the doctrine of product and service liability so that service providers and manufacturers can be held accountable for defective services even where there are disclaimers in boilerplate contracts. In addition, provisions in other legislation like the Indian Contract Act 1872, specifically with respect to the free consent, fraud and misrepresentation, constitute significant checks against exploitative contractual behavior. Apart from legislative and judicial actions, various reform-oriented proposals have also been suggested by legal experts and policy researchers. One of the most significant proposals is the use of plain and simple drafting of standard form contracts. Legal jargons must be simplified for common people so that they can give their informed consent. Plain language law, which requires contracts to be drafted in simple and lucid language, has been implemented in many jurisdictions across the globe and can be useful in the Indian context as well. The second proposal for reform is to create a system of regulation or oversight board to pre-screen standard form contract in specific industries like telecommunications, banking and insurance. The agency is to screen templates of contracts so that the contracts do not have unfair terms and abide by consumer protection standards. Besides that, companies can be encouraged on a voluntary basis to use fair contracting practices. Example, by including short statements of significant terms or offering customers the option of customizing limited facets of the contract. So to conclude, standard form contracts are essential for effective and standardized transactions in the fast moving business environment of our times. Though they are highly beneficial in terms of speed, cost effectiveness and standardization, their intrinsic absence of negotiation and imbalance of bargaining power can result in disproportionate consequences to weaker parties. It is essential that judicial as well as legislative frameworks keep improving so that the contracts do not subvert principle of justice and informed consent. Finding the perfect balance between efficiency in operation and fair treatment will render the standard form contracts legitimate and effective in both business and consumer environments. With this, we come to the end of today's lecture. Thank you very much.